I will also inform the court that I have attempted to reach out to Mr. Mee for the last 2 months.
Thank you. Be seated, please. This is Roger Hillygus versus the State of Nevada, case number 25 CR 211E. This is the time and place set for a hearing in regard to an appeal in this matter from the Story County Justice Court. Present on behalf of the State of Nevada is Roy Stralla. Are you Mr. Hillygus?
Yes, sir.
Present in court is Roger Hillygus in this matter, the appellant. Do we have Mr. Hillygus' counsel on remotely? Mr. Mee, can you unmute? I can't hear anything. I'm not sure if you can hear me.
Yes, sir, I can hear you.
Okay, I can hear you now too. We can hear you in the courtroom. Can you state your appearance for the record, please?
Michael Mee, 13726, on behalf of Roger Hillygus.
Okay. Are you prepared to proceed, Mr. Mee?
Your Honor, I am prepared to proceed. I'd like to address our opposition to the motion. I did send that out this week, and I don't know that the court has received that. So if the court hasn't received that, I'd like to address that issue first.
I have not received that. So let me make sure we're all talking about the same thing. The Nevada on September, well, it's filed September 19th. We have a motion to dismiss the appeal. So that was filed September 19th. I do not have in my file any response to that. You're indicating, Mr. Mee, that you sent a response?
Your Honor, we mailed up a opposition to that motion earlier this week, I believe on Monday. So I understand that that would be untimely as far as the state's motion. However, that has been sent to the court. And my request would be to permit the court in the state to consider that opposition and have time to reply before we move forward with the hearing. In the alternative, I would be prepared to address the state's motion orally.
All right, let's do this. Let's have an argument on the state's motion, oral argument. I'll entertain that today. I will indicate that it is not my intent to issue a ruling on that motion today. It's my intent to wait for the response to that. Does the response, as you indicate, it's untimely, does the response address that untimeliness in regard to asking for leave to file a late response, or how is that addressed, or will it be addressed in a separate remote motion for leave to file a late response?
Your Honor, I did not address it in the motion. I can certainly address it in a separate written filing. Otherwise, I was going to address that orally today as well.
All right. Well, let's proceed with argument. First, from the state of Nevada on the motion to dismiss only, not on the merits of the appeal at this point.
Judge, I'm put in a rather tough position to argue my motion when I don't even know what their opposition is at this point. I would submit the motion on what we've presented to the court. It's basically on technical grounds that the provisions of NRS Chapter 189 were not fulfilled in the request for a hearing, and also the Nevada rules of criminal procedure were not followed. I don't know how the defense is going to deal with those issues. We have precedent in this court that I believe it was Judge Russell before you were appointed, Your Honor, that those are grounds to dismiss an appeal. We have State v. Garcia. I don't have much more of a citation than that. It's been within the last year, though. So really, at this point, Judge, I just submit my motion and would reserve my right to rebut any argument that would be made by counsel with regard to their opposition, because I'd like to hear what they have to say if they have an excuse of why they didn't follow the statutory rules that seem to be need to be followed. In fact, the language is in there, you must do this, and that didn't happen in this case. Without talking about the merits or the tortured procedural history of the case, Judge, at this point, I would just submit the motion, and that would be the basis of my argument.
Thank you, Mr. Stralla. Mr. Mee.
Thank you, Your Honor. So there's two issues primarily in the state's motion that allege that there's inconsistency with the statutory requirements. The first issue is in regards to the timing of an application for scheduling this appeal to come before this court. And the second issue is to deal with the filing of the opening brief itself. I'm actually going to start backwards just because this is the order I have it in my notes. But the opening brief, the state cites the rules of criminal procedure, but there's also the First Judicial District Court local rules, which provide a 30-day briefing schedule for the opening brief from the time the parties are provided the transcript in the case. Now, the transcript in the case was filed well before we filed the opening brief. However, my office was not notified that the transcript had been filed, nor were we served a copy of the transcript when it was filed. We unilaterally reached out to the court staff to get a copy of the docket in this case, and only by doing that did we discover the transcript had actually been filed. I then requested a copy of the transcript via email. There was a 7 or 10 day delay in providing that transcript in response to my email. The opening brief was sent to the court within 30 days of us receiving the transcripts, which is what the local rules are designed to do. There is a separate issue of it not being file stamped until a few days later, but the point is, although it appears that the opening brief was well beyond the 30 days from the date the transcript was filed, the local rule refers to when the parties are actually provided the transcripts, and our brief was completed and submitted to the court within that 30-day period contemplated by the local rules. In reference to the application of setting this matter for a hearing, it's a little bit more complicated than the opening brief timeline issue. Similarly to that, because the transcripts had not been provided, there was a series of emails where I was communicating with court staff regarding the scheduling of this matter, a briefing schedule or scheduling of this matter with the court. In those emails, there was a discussion of court staff being in communication with chambers, and that the court would reach out to the parties for further steps. And that was in response to our questions regarding scheduling this matter. So essentially, our opposition attaches those emails and makes the argument that I think should be accepted by this court, that if you look at the rule for applying for a setting for an appeal from a lower court to district court, the rule requires the appellant to apply for setting that matter for hearing, but it doesn't require that application be made in a filing. So from our perspective, our communications with the court staff regarding those issues within the time frame and the court staff's response regarding those inquiries, there's no reason that wouldn't be something that could constitute an application within the meaning of the statutory scheme, given the statutory scheme does not specify that the application has to be made in a filed pleading. So that is the matter that is addressed in our opposition, and the only evidentiary issue that is raised in the opposition that the state is not aware of is those emails with court staff that are attached. So I understand it puts them in a position of not being able to address that.
All right, let me see, you know, as we await your response, and I'll review that as well. I just want to make sure I've got some clarity on, I guess procedurally, where this stands. As I review the record, your notice of appeal was filed on June 20th, 2025. I don't think there's any dispute about that. Is there, Mr. Mee?
That is correct.
Okay. The application for, to confirm the scheduling of appeal, that was filed on August 25th, 2025. Is that accurate?
I don't have it in front of me, but yeah, that sounds consistent. Yes.
Okay. And it looks like the order from the court ordering everybody to, the parties to appear for a setting was issued on September 5th, 2025. So, you may not have that in front of you either, but that's what the file stamp seems to indicate. All right. Mr. Stralla, was there anything you wanted to address in response to,
Sure, Judge. The only thing I would say is that the court ordered a hearing on this on September 5th. I don't understand why it took them almost 2 months after to file an opposition to our motion. I'll leave that to Mr. Mee. That I don't understand, Judge. Maybe he can address that, but we're just asking that this case be dismissed on procedural grounds today, Judge. If Mr. Mee would have reached out to our office and asked for some time to file for an extension to file his brief, if he would have contacted me, I can't speak for Ms. Langer, I would have granted. I routinely grant that on these type of matters, but I'm not aware that he reached out for any type of extension from us that we could have made the court aware of.
okay, thank you, Mr. Stralla. So here's what I'm going to do today. This is as has been indicated, this is a procedural step because the state of Nevada has indicated that this court does not even have at this point jurisdiction to hear the appeal. So the first thing that the court has to decide is whether or not I do have jurisdiction under these procedural rules to move forward to the merits of the appeal. The state has filed its motion to dismiss that was filed on September 19th. Before today's date, there was no response to that. I'm advised today that a response is on its way, and I intend to review that response first and foremost for some sort of explanation of why the court should entertain a response that is filed past the deadline that it was due under the local rules. And then secondly, if that hurdle is cleared, then I'll review the substance of the response to the motion. The state will have the opportunity to file a reply, or I guess what we'll call a provisional reply in the event that I do end up entertaining the merits of the response. I will issue at that point, after reviewing all that, a written order on the motion to dismiss. If the motion to dismiss is granted, that will be the conclusion of the appeal. If the motion to dismiss is denied, then our court staff will be reaching out to the parties for another hearing to occur on the merits of the motion. But the first thing I need to decide under the law is whether or not this court has legal authority to proceed to the merits on the motion. So that's what I intend to do. Was there anything else you wanted to address today, Mr. Stralla?
No, thank you, Your Honor.
Anything else you want to address today, Mr. Mee?
Thank you, Your Honor. No.
Your Honor, may I address the court?
Mr. Mee, your client wants to address the court. I don't know what your position is on that, or if you want to address that in any way.
He can address the court. That's fine.
Okay, go ahead, Mr. Hillygus.
Thank you for this opportunity to address the court and bring some clarity to what we're facing here today. The jurisdictional question would, and if it is denied of my rights, would deny a criminal defendant his due process rights, because as a client of the state of Nevada under the Department of Indigent Services, at the bench trial on June 12th of 2025, I had representation through the state of Nevada Department of Indigent Services, Attorney Ryan McPhee. On that day, a judgment of conviction was held by the the Justice of the Peace here in Story County, Eileen Harrington. A sentencing was also happened on that same day. Upon exiting the court, or even before walking out from past the bar, I informed my representative, Mr. Mee, or no, excuse me, Mr. McPhee, that I intended for him to appeal the conviction for the reasons that there was no evidence submitted in the trial, the bench trial, that the judge had recused herself. Judge Eileen Harrington had recused herself for bias and conflict of interest. She later decided to come back in, which is a violation of anybody's understanding of bias and conflict. Once you have that, you cannot just ignore that and say, well, I won't be biased, because you've admitted to being biased. And the reason for her bias is that her clerk is the wife of the arresting officer, Joseph Welch, who did not observe or witness anything in this case. He made an arrest based on hearsay, and this is all can be proven. So I would object to any motion to dismiss this appeal for grounds of procedural, as it would be a violation of my due process as a criminal defendant in this state of Nevada, because the state is the one that has assigned my representation as Mr. Mee. I will also inform the court that I have attempted to reach out to Mr. Mee for the last 2 months. Every week I've sent him a message, a voice message through his service, and I had witnesses to that. I also sent numerous emails and many messages on the portal that he provided me. I had been asking for a Zoom link for weeks now, and this is 2 months of lack of communication to be provided by the district attorney's office, their response to his appeal, which was filed August 31st, which I just gotten a copy of that not too long ago. So the state did not respond to the appeal that Mr. Mee, the attorney, filed on August 31st. So then they want to file a motion to dismiss, and now they want to argue it on procedural grounds because Mr. Mee failed to address that. Had I known that any of this was happening, I would have been on top of making sure that a response was done in a timely manner. So I would object to the motion to dismiss filed by the state, because they should have filed a response to the appeal. This has been going on for 6 years now, and I'm being prejudiced by the state failing to properly represent me in this matter. I followed all the appeal. I personally, with my ADA advocate and representative out of Texas, who has also attempted to reach out to my attorney, we have attempted to follow all of the appeal rules that are set by the court. So that day I informed Mr. Ryan McPhee that I intended to appeal. I submitted a letter that day or the next day to the court, the Justice Court, that I intended to appeal. They then sent that to the Department of Indigent Services, who appointed me Mr. Mee, who I had asked for the docket, which I had not received. I had asked for the response, which was never done, and any other communication to be kept informed. So I would object to my attorney not appearing here in court personally and having to appear by Zoom. I am in Texas now. I had not heard until this morning that he had gotten a Zoom link. So I thought he was going to be here in Virginia City to argue the appeal that I had been provided. And he was not here. And I really had a hard time understanding and hearing everything that he was saying. But I hope you, Your Honor, were able to capture everything that he was saying.
I was.
Because I believe that he has merit in his argument that he was in communication with the clerk. There were emails that were being tracked, passed and transferred back and forth to make sure that this went off like it was supposed to. Without sounding completely frustrated, this case is a clear abusive process by the district attorney. They are the ones that provided all of their evidence to me 6 years ago. They know that there has never been a crime committed in this case. They have the evidence that they provided to me. I can prove that they falsified and perjured themselves, and they encouraged a witness to perjure herself. And this can all be proven because there was no evidence submitted for this bench trial with a judge who recused herself. So without any evidence, with the exception of perjured testimony, which I can prove through body cam and through their evidence, that this case should have never gone forward from day one. And on procedural grounds, I understand that you want to have the proper jurisdiction, but I believe that as a criminal defendant, I have rights and that the state is representing me. And if they fail, there should be sanctions, and I should be provided the opportunity to have proper representation that's going to appear in court from Las Vegas. I didn't want somebody from Las Vegas. I didn't ask for somebody from Las Vegas, 450 miles, 8-hour drive away. I expected my attorney to be here. I'm here. I live in Texas. This case has been drug on and on and on. There has been setting after setting after setting. This is just more, this appears to be more of their playbook. Drag it out, drag it out, drag it out. Cost me, cost me, cost me. Have my supporters defeated because they want to see justice, and justice denied is happening year in and year out. This case really needs to be investigated at a high level because there's a lot of people involved that are denying me justice. And I have filed documents explaining everything that's happening here. And if this case docket from the Justice Court is purely reviewed, they're going to understand and see that there are a lot of violations occurring at different levels. So I appreciate you giving me this opportunity to address the court and object to my attorney not being here and object to my due process rights being violated. Thank you.
All right, thank you, Mr. Hillygus. All right,